Welcome to Short Legal Briefs with Josh Long, where experts in the natural products industry explore the intersection of business, law, and regulations. Tune in for the next 15 minutes to learn about policies and controversies affecting dietary supplement, food, and beverage brands.
Welcome to an episode of Short Legal Briefs. I'm Josh Long with Natural Products Insider and Informa. Joining me today to discuss recent developments at the Food and Drug Administration are representatives of four industry trade associations. Steve Mister, President and CEO of the Council for Responsible Nutrition, Michael Mcguffin, President of the American Herbal Products Association, Dan Fabricant, President and CEO of the Natural Products Association, and Duffy Mackay, Senior Vice President of Dietary Supplements with the Consumer Healthcare Products Association. Gentlemen, thanks for joining us today to discuss these issues. Lauren Israelson, President of the United Natural Products Alliance, could not make it for the program, but we will incorporate his remarks in this program. We recorded them in advance. I'd like to turn to the news. Recently, the FDA proposed mandatory product list for dietary supplement products yet again in its budget proposal to Congress. Meanwhile, industry stakeholders, including some of the people on this program, have advocated for broader reform to the Food, Drug, and Cosmetic Act, which would amend the law governing dietary supplements. And just last month, FDA reaffirmed its position that N-acetyl-cysteine, or NAC, is excluded from the definition of a dietary supplement. However, the agency strongly signaled it will not enforce against these products if they are otherwise not in violation of the Food, Drug, and Cosmetic Act, and it's still considering a rulemaking with respect to this ingredient. I want to get all of your reactions to these developments. We will start with Michael Mcguffin of the American Herbal Products Association. Michael, you have 90 seconds to weigh in.
Thank you very much, Josh, and I do appreciate this opportunity. I know there's going to be a lot of discussion today on mandatory product listing or, MPL. But frankly, there are other priorities. If we take the perspective of the friends, families, neighbors, we usually refer to them as consumers of dietary supplements, and look at what they need, which in our view is advancing their health with access and education for dietary supplements. There are other priorities. We know that there's an obstacle to our sale of ingredients like NAC, like CBD, because of a prior drug restriction that exists in statute. We ought to go tackle that. We ought to try to change that. There are restrictions to dissemination of truthful and not misleading information that's in the statute. That too bears our attention. We ought to see if we can't provide better education for consumers. There's a continuing concern about new dietary ingredients and proper safety reviews of those. We view that some of that is because we're not yet clear where the boundary lies. We ought to get into the statute and make that perfectly clear. So again, if our focus is on consumers, we would prioritize other activities. If we got an ounce of energy to go change the law, let's change it in places that will benefit consumers. Thank you.
Thank you, Michael. Duffy, what are your thoughts?
Thank you, Josh, for this opportunity to discuss DSHEA reform. Most supplements today are safe quality products made by responsible manufacturers, but a lot has changed since 1994, including the size, scope, and sophistication of the supplement market. Today, there are ingredients, products, and technologies that were not foreseen in 94. And as the market has expanded, so has a number of non-compliant companies marketing poor quality or at worst, risky products. Because FDA can't adequately regulate the volume and variety of products on the market, we see retailers filling the gap with a patchwork of programs used to differentiate quality supplements from fraudulent products. States feel the need to enact laws to protect children from potentially dangerous supplements. And there are categories of products that have been publicly deemed high risk for adulteration. None of this would occur if supplements were regulated under a framework that provided better assurances to all stakeholders regarding product safety and industry transparency, while fostering scientific innovation. A mandatory product listing is an important first step, but it needs to be coupled with other proposals that will ensure more facility inspections, encourage scientific research, and provide FDA better tools for enforcement against unlawfully marketed and dangerous products.
Lauren Israelson, what are your thoughts on the issue?
Regarding NAC, good news, bad news. The agency apparently is saying in the absence of safety concerns, which I think we all knew, that FDA will consider exercising enforcement discretion. Let's interpret that as you can sell NAC if it's otherwise labeled and promoted legally. That's good news. On the other hand, they say they're going to issue further guidance. What could that possibly be? We will find out, but in the meantime, I believe industry can proceed. Regarding other critical issues, mandatory product listing, we would like to see a bill. It's the details that count. We're prepared to support if we find a bill that is fluid, streamlined, designed to support FDA's basic requests, that is not burdensome. Three things I would suggest regarding the DSHEA amendments: exemption to labeling or third-party literature. We need to be able to communicate more directly to consumers and others information that is truthful and non-misleading. That's difficult to do today. Second is intellectual property protection. How do you invest in research if you can't find a plausible way to make your money back? And finally, FDA's inspection capability is stretched thin. There should be a way to support FDA through an external process to increase inspection, which increases product safety and quality.
Steve Mister?
Thanks, Josh. Like the other associations, CRN does see a broad need to amend a lot of provisions to bring DSHEA up into the 21st century. But I'm going to spend my time, I think, today dealing specifically with mandatory listing and a narrative that's out there that's misinformation, that a mandatory listing is in fact pre-market approval. I think the industry knows that we have fought even prior to DSHEA for the right of industry to bring products to market without FDA having pre-market approval. And a mandatory listing stays in that vein. It does not allow FDA to pre-approve these products. Our mantra for this has been from the beginning that mandatory listing should be a birth certificate, not a driver's license. FDA doesn't have the ability to say no in a mandatory listing situation. So even in situations like N-acetyl-cysteine and CBD, these products could and would be included in the mandatory listing. The advantage to FDA, of course, is at least then they have a complete and full view of what's in the market, but they don't have the ability to keep the product out of the listing if it's presented for entry. And of course, the advantage to the industry is it allows us to continue to innovate, to bring new products to market, and not to be hampered or slowed down by what is simply an easy administrative task as you're coming to market. Thanks.
Thank you, Steve. Dan Fabricant, you get the last word on this issue for now.
Fantastic. Yeah, MPL is pre-market. We're going to start there. We're going to start with NAC. The agency is never going to say, we're the only ones still left in the game on NAC. Our suit is still active. FDA is never going to do it about face. They've always got to save face. They've always got to have a way out. So if you look at NAC as an example, what would have happened? FDA would have said, we don't think it's a dietary ingredient, so we're not going to put it on the list. It's not a birth certificate. FDA is not looking for a data dump. They've said that. Pew Charitable Trust, who other associations are partnered with, has said that as much, that it's got to be some sort of a checkbox or prohibited act. So that's exactly pre-market approval. If you don't get on that list, do retailers like Amazon carry you? More than likely not, as we've seen already in practice with NAC. So MPL is a horrible idea. And I think to Michael's points, in terms of priorities, why is this a priority? How does this benefit Americans' health? How does it benefit the industry? And how does it benefit the agency? The agency needs to get back out there. They need to get back to pre-inspectional levels, pre-COVID inspectional levels. And that's really what the priority should be. The laws work. I've been on both sides of it. I can say affirmatively, the laws work when they're put into place and when there's oversight. That's the biggest issue. There needs to be oversight. NAC is a prime example of that. We wasted so much time, so much money, so much effort, and made so much duress for consumers who were looking to stay healthy for what? What was gained? Thanks, John.
Yeah. Thank you, everybody. We're going to jump into what I call the lightning round of questions. Each of you will have 90 seconds to answer these questions. We'll start with Steve. Steve, I wanted to ask you about FDA's recent response to your citizen petition, CRN citizen petition on NAC. So, you know, the courts give a lot of deference to an agency's interpretation of a statute that it's charged with administering, particularly when the meaning of a specific provision is either ambiguous or just simply not addressed. With that said, why do you believe that FDA's interpretation of the drug exclusion provision is unreasonable? And second, what does CRN intend to do about it to further challenge the agency's position? Thank you.
Thanks, Josh. Well, you know, you're absolutely right about the deference that the courts give to the agencies. There's something called Chevron deference, named after a particular court case, that really gives the agency a great deal of latitude, and they have to show that they've in some way exceeded their discretion for the court to overturn it. And that's why this issue is particularly troubling for us. From FDA's brief, it's very clear they intend to dig in and fight this in the courts. Having said that, I would say we think their reasoning is completely faulty. It overlooks the fact that before DSHEA was enacted in 1994, there was no pharmaceutical company out there that had any expectation of getting a monopoly over their ingredients. It simply did not exist until the law was enacted. And so from that respect, this is a retroactive application of a statute giving pharmaceutical companies a monopoly when at the time they would have been doing this research, they would have had no expectation of the monopoly. And then as far as what our next steps are, we're considering all things on the table. But for the reasons that I just outlined about Chevron deference, I think our better solution is with Congress. It's time to go back and look at 321 FF 3B and to revise that provision in such a way that drug companies do not get an infinite monopoly over these ingredients just because they might have won an economic race to market.
Lauren, a question for you. Lauren, a question for you here on DSHEA. As you well know, the law created a balance between consumer access to natural products and giving FDA the tools to ensure that the products are safe and that the agency can take action against products that are potentially dangerous. How can mandatory product listing be crafted in a way that preserves that balance?
That's the big question. This is FDA's #1 priority. They really want this authority. As they have articulated more recently, what is the underlying purpose and reason for this? Because there are other dietary supplement labeled databases that are available and are fairly robust. It's my sense that the agency believes that this would give them additional enforcement tools and authority, that the absence of registration or listing would automatically put a product into a misbranded, mislabeled category. It streamlines the administrative process by which FDA can get to a product that otherwise is more cumbersome. Whether that is appropriate is the big question. The other one is really going to come down to how complicated, expensive, and difficult would this process be? How much minute detail would need to be reported to FDA? In other words, what is essential information that is relevant to what FDA needs to know to do its job? So we would like to see bill language. Boils down to that. There's been a lot of discussion with congressional staff and between trade associations. No predictions as to outcome. I see why FDA wants this, but I want to see specifics.
Dan Fabricant, you made an alternative request in your citizen petition to FDA that the agency undergo a rulemaking on NAC. And MPA subsequently sued FDA in U.S. District Court. That case remains active. My question, two questions. One is, what is the ultimate resolution that you want, your organization wants? And does FDA's recent response to your citizen petition get you there?
Starting with the last question, no, it doesn't get us there. It seemed like we were in a period of enforcement discretion, which was our read. I mean, we had this conversation, Josh. We predicted that would be FDA's solution. It was. We gave them an out on our citizens petition and the lawsuit, and at least are moving that direction. I think everything that's been in our complaint to this point is what we want resolved. The issue on FF3. I mean, you've got a part of the law that going back to 94, some 28 years ago has never been, that muscle's never been flexed, right? That muscle needs to be flexed, not just for NAC, but likely for the other cannabinoids, for other ingredients. I think it's, everyone talks about innovation. The world we live in, drugs and supplements and foods run into each other. Natural components are going to run into each other. It's a spectrum. It's not always, a hard and fast wall on things. So how do we balance that? So ultimately we need the agency to interpret that part of the statute. They never have. They've avoided it. They've kicked the can. They've got to address that at some point. Do we know that we're going to be able to get through that there with where we're going? I really can't say much on that as we still have an active suit. I think the other side of it is there was damage done to the industry, damage done in terms of some sort of messaging. I don't know how it happened, but it led the e-tailers to delist NAC from their platforms. Also, certificates of free sale were denied. So we have to put mechanisms in place to prevent that from happening in the future. While it's a good first step, enforcement discretion for NAC, it's the easy, logical step. There's a lot more that needs to be done.
Thank you. We're going to move on to Michael. Wanted to ask you about mandatory product listing. I know that you've raised a number of concerns. Two questions, Michael. What are your principal concerns with MPL? And we know that lawmakers are working on this. Is there room for compromise?
Thanks again. We have expressed our views rather boldly and clearly. We have some kind of basic. We don't think it's necessary. We think it's redundant. The dietary supplement label database is already there. We don't think it'll work. But our main concerns are more on that we don't really know how FDA would interpret it. And if you look at the history of the last 60 years, FDA always interprets this way to reduce access, to reduce choice. Industry and I think consumers always move the opposite way. So our concern is that we don't know exactly how FDA would interpret this to reduce access, but we have to assume that they would. It would be, I think, naive to think that FDA would not try to reinterpret it the way that they've reinterpreted what the statute says about new dietary ingredients, the way that they're applying the prior drug restrictions. And if I go back to my opening point, a main concern, Josh, is that there are better things to do. If we've got an ounce of energy to amend the law, let's amend it where it's needed. I heard Duffy talk about enhanced CGMP inspections. That should happen. I heard Steve talk about amending 321FF3B. We brought that idea to the group a year and a half ago. It's really great to hear that that's now got some attention from others.
Thank you, Michael. Duffy, your organization has expressed support for MPL. Two questions for you. And you may have addressed, you partly addressed those at the opening, but I'm going to give you another chance. Why is MPL a good idea? And I want to give you a chance to respond to some of the criticisms by Dan Fabricant and Michael Mcguffin regarding this issue.
Well, a mandatory product listing at the most simple level is intended to provide FDA visibility to what products and ingredients are on the market. But FDA is not the only stakeholder. We have retailers, we have e-retailers, we have healthcare practitioners right now. And this is not a message that I'm fond of, but they're given a message, buyer beware. Buy from brands you trust, buy from retailers you trust. And why is that? Because there's an assumption that there are these categories and locations where you can buy supplements for which you risk buying an adulterated product. And at a simple notion, fresh air is a great disinfectant. And when the industry opposes something like a mandatory product listing, it's hard for outside stakeholders like doctors not to say, what is that industry hiding? Is it pure powdered caffeine? Is it DMAA? Is it BMPAA? We have a history of questionable ingredients that have reached the marketplace, and FDA has limited tools to communicate that to outside stakeholders, so much so that they've had to put two places on their website, the product and ingredient list and the ingredient advisory list, where they put lists of ingredients, where there's over a dozen ingredients. And FDA has questions of whether the legal status or the safety of these ingredients. And it's limited to putting a hard to find spot on its website to communicate to other parts of the agency and retailers, stay away from these ingredients. And a mandatory product listing will provide an authoritative place to work all that stuff out.
Thank you, Duffy. Dan, you're obviously opposed to MPL, and you've said FDA should effectively use the tools that it already has. In your view, what should FDA be doing today to hold bad actors accountable and to incentivize just more compliance, especially with those people that are in the middle of the bell curve? They're not out there intentionally selling illegal ingredients. They may be, they may be complying with CGMPs, but they may be out of compliance with other areas. What does FDA need to do?
Well, I think first and foremost, let's cut off most dangerous, right? Is what is FDA's job? Is they are a law enforcement agency. I hear this talk about transparency and, oh, we've got to have, these nice to haves. No, FDA's job is to take care of the bad guys. We can go now to Blackstone Labs site, who is currently under federal indictment, and find some of the same ingredients that were subject to that indictment. FDA has access to Al Gore's internet, so I'm pretty sure they can type it in on the Google machine and find those same things and take action and follow up. Why doesn't that happen? Why is that now my member's burden? Why is that the responsible industry's burden? That's FDA's challenge. They need to follow up. They need to be thorough. And to Michael's point, they need to engage the legitimate industry in that vein that we are the legitimate industry. We turn over hundreds of cases a year. Do all of them lead to warning letters, enforcement actions? No. But I think they know they have a partner in the legitimate industry. Instead, that's not the story. Duffy tells a story, well, it's very tough for the agency to get the word out. No, it's not. They have no problem getting the word out. That's not the challenge at all. The challenges are to getting the right word out about the industry. Their mantra, their mission is to protect and promote public health. They're not doing a lot of either right now. If we're not getting GMP level back to where it was pre-COVID, if we're not actually going, hey, these are the folks, how bad would it be if the FDA went out there and go, hey, buy products from people who are members of trade associations?
Thank you.
But instead, I don't think so.
Thanks, Dan. I do want to mention, you said Blackstone Labs was under indictment. All those entities and individuals that were prosecuted by the DOJ have actually pleaded guilty or been convicted by a jury. I think that case is pretty much wrapped up. I just wanted to mention that.
You're right. While they were under indictment, we sent over emails because we continue to find those ingredients on their site being sold in commerce. I'm sure that when you,
right. I was just it was just kind of bringing out where that case. We're going to move on to Steve Mister. Steve, your organization has been in favor of MPL. You just heard from Dan Fabricant on his criticisms. What leads you to conclude that the listing will be used in a way that will either incentivize greater compliance or result in more vigorous enforcement against these bad guys, like, for example, the Blackstone Labs? I mean, that's a perfect case in point right there. FDA did take action in that case, but there's others out there that are selling illegal ingredients and they're not in federal court right now.
Well, Josh, Dan is absolutely right that there's a lot that the agency isn't doing that it already is empowered to do. And we should continue to keep the pressure on the agency to enforce the laws that are already on the books. We should also be trying to get more resources directed towards the Office of Dietary Supplement Programs to make sure that they have the tools that they need. But along with the things they already have, they need visibility into the industry. It is easy to understand when the agency says we cannot regulate what we cannot see. And regardless of what other tools they may have, the reality is that they do not have a handle on the breadth of the industry. Even the ODS database that's housed at NIH is a completely voluntary database. It has products in there that are 20 years old, and it has products that are listed as on market when they're not on market. Many manufacturers don't even know that they're in that database. It's not the answer. The answer is to give FDA a place where they can find out what is in the market at any given time. That's what mandatory listing does. contrary to what you've heard, the legislation can be written in a way that FDA does not have discretion to keep products out of the registry. It simply becomes a place where when products come to market, they're listed there, even when FDA doesn't agree that it's a legal product. But by being in the database, it gives FDA visibility to see what's in the market at any given time.
Thank you, Steve. Michael, I think I skipped you. I was gonna go to you earlier, and I skipped down here. I wanted to ask you about, the broader reforms that you're advocating for, but you've already really mentioned that. So I wanted to pivot to something else since you already addressed that issue, which is NAC. Dan Fabricants Association requested in the alternative a rulemaking on NAC. FDA is considering that. What do you think the implications of that rulemaking could be for the broader industry? Are you in favor of it? And how does it tie into CBD in your view?
Sure. We did submit comments to support both the NPA's communication to FDA and CRNs. And to some degree, we duplicated the thoughts that they had already expressed. The main point being that the idea that that should be used retroactively, that on October 25th, 1994, we were all supposed to walk out onto the highway and glance down to the horizon and see if we could find any evidence that anything that we were currently selling might have been subject to authorization as an investigational new drug is ridiculous. It's not pragmatic, and it's completely contrary to the way that laws are generally implemented. Retroactive needs to be established by statute. So that's kind of the status today in terms of if FDA prevails in this, at what point do they say, hey, we found somebody started doing research on chamomile back in 1964. At what point do they take the next ingredient? We're concerned about it. We support the actions of the others, and we chose to take a more supportive position rather than be the one out front, partly because it's fun for Dan to say, what are the rest of you guys doing? So we set ourselves up for that.
Lauren Israel said, regarding NAC, you mentioned that earlier, the agency reaffirmed its position that NAC is excluded from the definition of a dietary supplement. On the other hand, it signaled it will not enforce provided firms are in compliance with the other requirements of the Food, Drug, and Cosmetic Act. It also signaled that it's looking at a potential rulemaking. So what is the good, the bad, and the ugly here?
Well, the good is I think companies can feel much more confident. They can put NAC back on the market. Certainly, I would advise that they are scrupulous about labeling health claims, all other aspects of compliance. If FDA is looking to ding a company, it would be for those kinds of reasons. Now, what is a little bit of a head scratcher is that they're exercising enforcement discretion. They recognize that there are no safety concerns that they can find with NAC. So I believe what we're seeing is FDA trying to, through rulemaking potentially, and I don't quite honestly see what is the necessity of rulemaking. The 25-page Stern letter that came along with the constituent update was quite thorough. FDA takes the position is, the way we read DSHEA and the legislative history says, the exclusionary provision that keeps supplements out of the market if a drug was sold either before or after the grandfather date of October 15, 1994, no matter what it is, the DS cannot be sold. I was in the room and these discussions were had, and that is not my recollection of what was agreed. This would be a prospective looking provision, and that products on the market previously would not be looked to. It's new drugs in the future.
Lee, this is the final question for Duffy. Your organization's advocated for broader reforms to the Food, Drug, and Cosmetic Act. Let's put aside MPL for a minute. What else are you looking for? Why is it important?
Well, I think it's been hit on several times by everybody here, but the notion that there is a significant gap in GMP or facility inspections. One of the most potent and powerful tools that FDA has is to go into a facility, do an inspection and evaluate their, how they take ingredients in, how they do their manufacturing, how they test for identity, all of the real key elements of product safety and integrity, including look at claims. All of the details can be looked at in inspection, yet we have this giant inspection gap, less than 10% of facilities being inspection, and that's just unacceptable. And a lot of improvements, a lot of the problems we've been talking about would not be here today if we knew that every facility was inspected on a more frequent higher frequency, if you will. And so the notion that we can get FDA more funding to fill this inspection gap, I think is a little far-fetched. And so there is a proposal on the table to authorize third parties to conduct an FDA audit with the intent of increasing the number of facilities for which a qualified or certified individual is inside of that facility, making sure that all of the rules are being followed, which will go a long way to really protecting the consumer and making sure that what's on the label is in the bottle and nothing more. So this is probably the most important second pillar of modernizing DSHEA.
Thank you very much. Dan Fabricant, Michael Mcguffin, Duffy Mackay, and Steve Mister, thanks for your participation in this program today. And audience, thank you very much for tuning in. You just watched an episode of Short Legal Briefs.
Welcome to Short Legal Briefs with Josh Long, where experts in the natural products industry explore the intersection of business, law, and regulations. Tune in for the next 15 minutes to learn about policies and controversies affecting dietary supplement, food, and beverage brands.